Hello and welcome to this video in the IP for Startups series by Keltie LLP. My name is Goodacre and I'm going to take you through what I think are the top 5 most important things you're going to need to know as you begin to protect your company's valuable IP assets. Okay, so on with point 1. And this is a really important point. There is no single form of IP protection. There are many forms to protect the different forms of creativity that your company generates. So for example, you may have heard of patents. Patents are there to protect technical innovations, so things that have an effect in the real world. For example, Trevor Bayliss' wind-up radio was patentable, as was the cyclone in Dyson's vacuum cleaner. On the other hand, you may have trademarks. Trademarks are there to protect your company's branding and the investment you make in the advertising of your company to make consumers realise that a product comes from you. Registered designs are there to protect the look and feel of a product. That can be important for some businesses. And copyright is also available to you for any creation that you make in terms of written word or drawings. So typically we think of this in novels or songs, but it can extend to things like instruction manuals and even software code. Your company will generate all forms of IP, and choosing the right one to protect each form is important, as is trying to get overlapping protection to make sure that you build a suite of IP rights around your company's valuable IP assets. Okay, so on with point 2. Now that we know there are many forms of IP rights out there, it's also important to know that those rights tend to fall into 2 main groups, what we call registered and unregistered. Now, registered, as the name would suggest, involves some sort of registration procedure where you apply for, go through some sort of formal examination procedure, and then obtain an IP right that's then registered on some sort of publicly accessible database. Unregistered rights, on the other hand, tend to generate automatically. Now, there are implications in terms of costs, timings, and strength of the IP rights you obtain through each of these procedures. And it's important to know how that works together and how you can build that into your IP portfolio as you go forward. Okay, so moving on to point 3 now, and this touches a little bit more on registered rights. Now, as I said, registered rights have to go through a formal procedure where you apply for, go through some sort of formal examination procedure, and then hopefully, if you're lucky, obtain your granted IP right. Now, unfortunately, people tend to fall in the trap of saying they have potentially a patent or a trademark the moment they file the application. But because of the examination procedure, nothing is fixed really. Your scope of protection is not fixed until you get the granted right. So when you're talking to others about your own IP and about their IP, it's important to realize whether you're talking about an application for a granted right or you actually have that right granted in your hands. Okay, so point 4 builds a little bit more on this idea that you may have your own IP rights, but you are living in a world where others have their own IP rights too. And so we're talking about registrability against freedom to operate, or FTO as it's sometimes called. So these terms are often confused, but in context I think they're relatively simple to understand. Registrability involves simply whether you meet the criteria for registration of the IP right you're applying for. Nothing more to it than that. Freedom to operate, on the other hand, is relating to when you have a product or service you're about to launch, where if you do so, whether that would infringe other people's IP rights. Now, you can do searches for both of these things, and that's where the context most comes into play. You can either do a search to determine what your chances of registrability are, depending on what's out there already. You can also do an FTO search, which involves looking for others' IP rights that you may infringe were you to launch. So it's important to know the difference between these 2 things and to use it appropriately. Okay, so point 5 is the fact that almost every IP right you can obtain is what we call jurisdictional. It only has power and can be enforced in the country or region in which it's been granted. Now, this is important because it affects what you can do with your own IP rights, but it also means that others can't necessarily take action against you if they don't have protection in your country where you're operating. You may have heard of international patents, international designs, international trademarks, but actually these are a bit of a nomenclature issue in terms of they don't actually get you to an international or multi-jurisdictional IP right. They're just an admin procedure that allows you access to national rights in the end. So bear that in mind when you're talking to people and investors and understand what your own IP rights should be. Okay, so those are my top 5 most important points in the basics of IP. If you want any more advice on any of the points raised, then please talk to an IP attorney. Otherwise, I hope you enjoyed the video, and until next time, goodbye.